If you have built-in capital gains on your existing assets, is there any way to get around that tax without breaking the law? Well, there is a legitimate estate planning strategy called upstream gifting that may do exactly that if you use it correctly. Hi, I'm John Strohmeyer with Strohmeyer Law, where we help our clients leave no unfinished business. While I am a lawyer, I am not your lawyer, so make sure you're taking the advice of your own attorney and not some talking head on the internet when making any decisions. Now, don't forget to like, comment, and subscribe. Today, we're going to be talking about upstream gifting. This falls under our potential avoidable costs in the Four Horsemen of the estate planning apocalypse. Because if done correctly, you can really minimize the future capital gains tax on assets that you own. But if you do it incorrectly, it can expose you to all sorts of risk, including nasty letters from the IRS. So, what is upstream gifting? A lot of people will think about estate planning as passing assets down the family tree, from parents to children and grandchildren and further descendants. Upstream gifting, on the other hand, flips that. Instead of giving assets down, we're transferring appreciated assets up to a parent or an older relative. Why? Well, we're trying to take advantage of the law that says that if you die owning an asset and it's included in your taxable estate for federal estate tax purposes, then that asset is going to get a step up in basis to fair market value on the date of death. What this means is that the person who ultimately inherits that asset can sell it without that built-in capital gains. Again, they received the asset with a lower basis, they died owning it, and when they passed it on, that person stepped up the basis under the tax code to a higher fair market value. So, for example, if you own stock with $5 million of unrealized gain, if you sell it, you're going to pay tax on that $5 million worth of gain. But if you gift it up to your parent and they hold it and die with it in their estate, then guess what? The basis will be increased to fair market value. Now, of course, you've used up $5 million of your exemption at the very least to gift that property up. If you had $5 million in gain and it was only worth $5 million, well, great. It only cost you $5 million in your exemption. But if it were worth $10 million, then you're eating through a lot of your exemption in the name of capital gains tax planning. Doesn't mean that there's a right answer for every situation. Does mean you're going to need to look at what is appropriate and what you're willing to part with in terms of exemption and tax costs. Now, why would we think about this? This wasn't a big strategy back in the 80s and 90s because the estate tax exemption was so low. For example, it was about $600,000 and the rate was very high, 55%. But now, here in 2025, the current exemption is $13.99 million per person, or just shy of $28 million for a married couple, meaning we have a large opportunity to gift assets to persons and they're not going to be using their estate tax exemption. And put in another way, upstream gifting will allow families to take advantage of that unused exemption to eliminate future income tax instead of estate tax. So, how do we do this? Well, obviously, the easiest way is just to make an outright gift. But once you've made an outright gift, you've given up all control over it. The person you've gifted it to could give it to your brother or sister, another family member, the pool boy, a charity you don't like. It's out of your control. So, a better approach is often to gift that asset to a trust for the parent's benefit. But we want to include some special rules in that trust. One, we want to make sure that the trust is structured in a way that those assets will be included in their estate for estate tax purposes. Again, we're looking to trigger inclusion so we get the basis step up. But we also want to protect it from being redirected to someone else or something else that we don't, including creditors. So something like a general power of appointment may be able to trigger both estate inclusion, but it can be overbroad, allowing for assets to go anywhere. Again, be careful when setting this up. So what are the other risks we want to think about? Well, next, we want to make sure that your parent is expected to live long enough. Hidden in the Internal Revenue Code is a law that says if you gift something to a person and that person dies and the asset comes right back to you, if it's been too short of a time, then you will not get that basis step up. Next, you want to make sure that your parents can't change their estate plan and leave the asset to someone else. Yes, you're giving them the benefit of this asset while they're alive, But you also want to make sure that you get that asset back if you're putting all the planning into place. You also want to make sure that the person you're giving this to doesn't have any lawsuits or debts that could otherwise put the assets at risk. Again, if you're giving it to them, you want to make sure that it's coming back. Finally, the estate tax exemption laws are up for change at any time. Here in 2025, more than likely we're going to have an extension of the current high exemption rates. But that still takes an act of Congress and right now, specifically an act of the Senate to get that taken care of. If it doesn't, then the exemption is going to drop to be about $7 million per person on January 1, 2026. This could have a whipsaw effect where you've gifted assets to someone who you thought had plenty of exemption, but it turns out the exemption was lowered and they don't, in which case they're going to end up paying estate tax on that potentially. So, when does this make sense? First, you're going to need to have some highly appreciated assets that you'd like to sell but don't want to trigger the tax now. Next, you want to make sure that older generation that you're gifting to has plenty of unused estate tax exemption. If you don't, potentially you're going to find yourself in a situation where you've triggered unwarranted estate tax in that generation in the name of avoiding income tax. The numbers may not work out your way, and so you want to be careful with that. Next, you want to make sure you have a close and trustworthy relationship with whoever's involved, or that you're using a carefully structured trust. Finally, you need to make sure that you've understood the loss of control and design the trust in a way that will make sure that things come back to you. Now, upstream gifting can be a very powerful strategy, but there are strings attached. It's not about hiding wealth. It's about shifting assets to the right people so that you can leverage those laws for your benefit. And while it will work, and while upstream gifting can work when implemented correctly, not every family and not every situation will qualify for this. So, as always, make sure you're talking to your own advisors about this, and we'll see you next time.